Hi everyone, it's so good to be back here again. Thank you so much for tuning in. I really appreciate you. Thank you for your love and your support right here. And it seems the problems are never ending in Nigeria because now it's now a battle between the president and the 36 governors of the country. And I wonder what is really going on because they have a case against the president, just as the president had a case against them earlier in 2020. And now there's a Supreme Court judgment over that very report. And also, the governors are saying that the president had allocated both the legislature and the judiciary in, in appropriation laws, and that has actually caused a lot of controversies. And now it has been in court, and now we're going to hear about what the conclusion of the matter is. So stay tuned. Don't forget to like this video. Don't forget to share. Don't forget to turn on the notification bell so that you can get updated anytime we drop a new video. And yes, without further ado, let us dive right into the details of this report. The Supreme Court has reserved judgment in the suit filed by the Attorney General of the 36 states querying the legality of the Presidential Executive Order 10 in 2020. President Buhari had in the executive order he signed on May 22nd, 2020, made it mandatory for all states to include allocations of both the legislature and the judiciary in the appropriation law. This, he said, was in compliance with Section 121, subsection 3 of the 1999 Constitution as amended. A seven-man panel of justices of the Apex Court, led by Justice Musa Datijo, reserved their judgment after listening to arguments canvassed by all the parties. The states, through their attorneys general, in a suit marked SC/C55/2020, where the Attorney General of the Federation was listed as the sole respondent, posed two questions for the Supreme Court to determine whether, having regards to the provisions of Section 6 and 81, subsection 3 of the Constitution, read together with Item 121, subsection 3 of the Third Schedule, the defendant is not constitutionally obligated and or charged with the responsibility for funding all capital and recurrent expenditure of the defendant is not constitutionally obligated and or charged with the responsibility for funding all capital and recurrent expenditure of the High Courts, Sharia courts or appeal and customary courts of appeal at the state of the Federation, being courts created under Section 6 of the Constitution. Whether considering provisions of Section 6, 80, 81, 120, and 121, whether the President's Executive Order Number 10 of 2020 made by the President on May 22, 2020 to compel the plaintiffs to fund states' high courts, state Sharia courts of appeal, and customary courts of appeal in violation of the constitutional provisions vesting responsibility for funding the said courts on the federal government is not unconstitutional and unlawful. At the resumed hearing on Monday, while adopting their processes, counsel to the plaintiff, Mr. Augustine Alege San, argued that salaries, emoluments, remunerations and allowances of judge were not supposed to be in any appropriation bill. Alege submitted that under Section 84, subsection 4 of the 1999 Constitution as amended, funds for such expenditure were charged and captured in the Consolidated Revenue Fund, not in the budget. Our position is that funds meant for the judiciary should be taken from the Consolidated Revenue Fund and handed to the National Judicial Council (NJC) for disbursement to heads of courts as stipulated in Section 6 of the Constitution. We have to admit to ourselves that what we are practicing in this country is constitutional democracy and not true federalism, Alege said. He told the court that his client had so far spent about 66 billion naira in the maintenance of state courts and demanded for a refund of the money. For his part, counsel of the AGF, Mr. Tijani Ghazali San, the acting director, Civil Appeals, Federal Ministry of Justice, told the court that he filed a preliminary objection and a counter affidavit in vehement opposition to the suit. It was also reported that he said the executive order 10 was based on a judgment of the Federal High Court that ordered financial autonomy for the judiciary at the state level. Ghazali contended that the said judgment followed a suit that was filed by the Judiciary Staff Union of Nigeria (JUSUN), in which the NJC, the AGF, and the AG of all the 36 states were listed as respondents. My lords, up to this moment, there is no appeal against that judgment, which they are now contending is different from their suit, Ghazali said. He added that the plaintiff's suit was a gross abuse of the court process and urged the court to dismiss the suit with reasonable cost. Alege, however, prayed the court to discountenance the argument by the AGF, stressing that JUSUN as a body lacked the court to dismiss the suit with reasonable cost. Alege, however, prayed the court to discountenance the argument by the AGF, stressing that JUSUN as a body lacked the local standing to file a suit in any dispute between the state and the federal government. Meanwhile, five senior advocates of Nigeria SAN Adegboyega Awomolo, Olisa Agbakaba, Sebastian Honorable Magaji Musibao Adetunbi announced appearances as amicus curiae friends of the court. So, guys, it was obvious that there's still a case here between the president and the 36 state governors. So there's a lot of court cases. We have the VAT, we have, so many, and we hope that, the country gets better. That is the most important. So, guys, that is it. Thank you so much for staying to like and share this video, and also turn on the notification bell to have a pleasant time. Bye for now.